Hello there. Welcome. Employment Law Show is what it is for the next 30 minutes. Thank you so much for joining us. John Scholes here. Beside me, employment lawyer, of course, Lior Samfiru, can be found at employmentlawyer.ca. Always make the phone call to talk to Lior or one of his team anytime. 1-855-821-5900. Help at employmentlawyer.ca. And as far as the websites are concerned, the handiest one for you to use covers all the matters we talk about weekly on the show. Pocketemploymentlawyer.ca. We'll drill down on that website and actually put it to the test a little later on the show. And we always have a main topic. Later in the second break, it's going to be fast facts about employment contracts. So we'll do that. Some phone calls from one of our radio shows across the country and so much more, Lior. So let's get busy. We always kick it off, get warmed up with the week that was, pal. What do you got this week?
Great to be here. Of course, employment law is such an important topic. If you have a job, you care about employment law. That's pretty much everyone. Whether you're full-time, part-time, whether you've been working for a month or for 45 years, you care. You must care about employment law because you have rights. And if you don't know your rights, if you walk away from those rights, you could be taken advantage of. Maybe not deliberately, but it can happen. So by watching the show, you'll be armed with the knowledge that you need to have to protect your rights, to stand up for them, to not be taken advantage of. And of course, you'll be provided with other resources that you can contact to help enforce those rights, including reaching out to me and my team across Canada so we can help you make sure that your rights are protected and enforced. There's other tools we'll talk about on the show, but the point is that you have rights, you have options, and if things don't go well at work, they're not always going to go well. Don't be frustrated, don't lose any sleep, don't quit your job. There's things that you can do to make it better, and the laws are there to protect you. We have very good, comprehensive employment laws across this country. Usually people that say to me, we don't have a good employment laws, it's really a function of them not understanding and knowing what those laws are. I only deal in employment law, and I can tell you we have very good employment laws. Don't believe me? Stay tuned for this show, and of course, reach out to me anytime in the office when I'm not on the show. But I always like to start off with the situation that came across my desk. Now, this particular case, there's nothing unique about it, but I had to do a bit of a double take when it came my way, and I really wanted to share. It's probably one of the worst severance offers that I've seen in well over a year. I got contacted by a gentleman who has worked as a manager for a smallish retailer for the last 16 years. Long time, of course. He was one of two managers, and the company recently decided to restructure and only have one manager working full-time. So they decided to let this person go after 16 years. The gentleman is also older, in his 50s. And of course, that was a bit of a shock for him. Well, his employer said, 16 years, we wish you all the best, and we're going to pay you 8 weeks. There wasn't an offer. They didn't ask him to sign. They just told him, we're going to pay you 8 weeks, and off you go. This person, of course, didn't think it was right, wasn't sure exactly what he is owed. Thankfully, I'm so grateful, he contacted me, and he had a simple question. Is that enough? Is that all I'm owed after 8 or 16 years? Guys, this is one of the worst severance offers I've seen in a long time, and I review severance offers all day, every day. This person is probably owed 18 months of severance. 18 months, offered 8 weeks. That's a huge dollar difference. So many employers don't understand or appreciate what their obligations are. I don't think this was a bad employer. I don't think this was an employer that was trying to get away with something. I honestly believe that they were ignorant as to their own obligations. I see this all the time. Luckily, he didn't sit on his rights. He didn't forget about it and move on. He contacted me, and I'm going to help him get those 18 months. What a massive difference. So again, nothing unique so much about the situation, but important to mention, it's very likely that when you're offered, you're going to be owed more. It may not be as big a difference. Maybe you're offered 6 months when it should be 18 months, but it's still going to be significant. That's why I'm here, and that's why you have to call me.
If you had to guess, Lior, where would this employer have gotten that 8-week number from? Some sort of statute, a minimum, or just pulled it out of thin air? What do you think?
So opened up the laptop, typed in severance and on Google, and gotten misinformation. That's what I see often. He may have come up with something under the Employment Standards Act that outlines that the minimum entitlements may be 8 weeks, but that's irrelevant. The person's full entitlements, as I said in this situation, is 18 months. You cannot, whether you're an employer or employee, get advice from Google. You have to do the smart thing, the right thing. In this situation, the difference here was 15, 16 months pay that this person is owed more. So be smart, do the right thing, get some advice.
Did a smart move calling you? Had he accepted it and walked away? Is there any going back?
Well, luckily in this case, they didn't even ask him to sign anything.
Right.
But if he had thought about it for a while, forgot about it, and contacted me 2 years later, that limitation period would have expired and he wouldn't have been able to get it. So luckily, he contacted me very soon. We're going to help him get what he's owed. It's going to be amicable. He's not going to burn any bridges. It's simply what the law provides for him.
EmploymentLawyer.ca, great website. Among other things, you can learn where to find our radio show on a weekly basis pretty much across the country. Tune in, call in, and possibly in a future show, one of your voices will appear on air, and we'll talk about your call. If they're good, we like to educate people with playing them on air here on this show. So we'll get to phone call number 1 right now.
Just let go from my job. I have been in the job for 2.5 years. I was told that they're restructuring and I don't fit with the team, given 4 weeks severance.
How old are you? What kind of a job were you doing?
I'm 59 and I was doing accounts payable supervisory job.
Ironically, accounts payable. How much is she owed?
Well, let's find out.
That's right.
So this person may well be upset and confused about the reasons she was let go. And I understand that. But from a legal standpoint, her employer is allowed to let her go so long as severance is paid. Even if her employer is not giving her the real reason, ultimately the reason should be put aside. From a legal standpoint, it's about the severance. Now, we talked on a recent show, and we talked about in many shows, about short service employees. So she's been there just over 2 years. She's not a long service employee. And I bet if we ask some people on the street, they'd say, yeah, 4 weeks after 2 years sounds okay. 2 weeks per year, that's fine. Not fine. Not even close to being fine. Owed much, much more than that. So rather than me tell you what the right amount is, I want to show you how you can find out for yourself what the amount is in this situation or your situation. We're going to use the severance calculator. You can find that at pocketemploymentlawyer.ca. Click on the severance calculator, by the way, free and anonymous. Let's do that right now and see how much this person is owed, which is not, by the way, 4 weeks. So we know that this person is in her 50s, is accounts payable, 2.5 years of employment. Said 4 weeks, that's what our employer says. Well, you see what the right amount. It's not 4 weeks, 5 weeks, or 6 weeks. It's 6 months of severance. 6 months. Huge difference, by the way, between 4 weeks and 6 months. Remember, short service employees are often and usually treated disproportionately better than longer service employees. Do the right thing, do the smart thing. Doesn't matter if you work for a short time or for many, many years. Call me or use the severance calculator. Do the right thing.
You know, you mentioned that, the initial phone call sometimes quite often with Lior is trying to walk someone off the edge of why did they get my job back? Why did they fire me? Well, don't worry about the severance. Yeah, but I want to know why I got fired. That's not right. Get my job back. They got to look past that at some point, right?
And listen, if I was in that situation, I'd feel the same way. You would feel the same way. You'd be upset. Why did they let me go? I didn't do anything wrong. I want them to give me an explanation. I want them to justify it. I want to show them that I don't deserve to be let go. That is understandable. But from a legal standpoint, as John said and as I've said, ultimately the law does not address that. They're allowed to let you go for no reason, bad reason, good reason, so long as severance is paid. That's why we speak so often and so much on the show about severance, because from a legal standpoint, that's the only thing that actually matters.
Again, employmentlawyer.ca to find a radio station in your market where you can contribute to this show weekly as well. Phone call number 2 is coming right now.
So I'm just calling on behalf of one of my friends. So he's got a known disability. He was let go from his job just earlier this week, and it happened right after he had brought the doctor's note to the employer saying these are the kind of requirements he needs. It's best for this employee to work the late start shift due to medications. Wondering what kind of accommodations could a person ask for, and though he was only at this place for, I'd say, about a week and a half, what kind of things could he go for?
Wow.
So here's how I understand the situation. He gets hired. Employer says, right, welcome to the team. Can't wait to have you. Employee says, by the way, just so you know, I do have some restrictions. I'm going to need some accommodation. Employer says, oh, we're letting you go. Well, no, can't do that. That is a human rights violation. You cannot be let go because you need accommodation. Whether you need that accommodation on day one or you've been working there for a while, that employer must accommodate. And if they decide to let you go instead of accommodating, huge issue, huge illegal conduct. That's a human rights violation. Some of the most important laws we have are under our human rights laws. You must abide by them. So yes, this person is owed human rights damages. Potentially, by the way, could actually get their job back with back pay. It's that bad what the employer did. So if you need accommodation, get that doctor's note, of course, saying or telling your employer what type of limitations you have. If your employer accommodates you, fantastic. If they refuse to accommodate you, if they let you go, if they punish you in any way, you know that that's wrong, you know that that's illegal, you have to call me right away.
Does that threshold for accommodation increase with the size of the company and their resources, like a mom and pop shop versus a multinational type of company?
Well, as a practical matter, sure, because you have to accommodate if you can. Well, a big company with many resources and many roles and a lot of different positions and options is going to be expected to use those resources to accommodate, whereas a small mom and pop shop may just not have the ability. There's just no roles to give that person. So yes, as a practical matter, the bigger the company, the more resources and options it has, the higher standard they have to abide by.
We have another phone call to roll through. It's going to be number 3 for the show, and then we're going to move on to fast facts about employment contracts. That's on the way after the break, so stick with us. Here's the phone number as we get into the break: 1-855-821-5900, help@employmentlawyer.ca. We're coming right back. Stay there. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Employment Law Show. Lots more to go. Our third phone call. By the way, you want to send a phone call along. Here's how you do it via the radio show. EmploymentLawyer.ca. You'll find a radio station in a market where you live. Call into the show, talk to us, and you may appear on this show. Lior, here comes phone call number 3. Listen up.
My wife has been working at a company for about a year. She's a pharmacist, and there's been talks about a move to another location, which is further away. But nothing has been very clear, and they basically said, whenever the time comes, we'll give you the legal heads up that the company must give you. Making that big of a change for us as a family is difficult. We will need another car, more expenses. What does the company have to do? What does she need to know as an employee of the company? What are her rights?
Nice. Good. Very
important issue, and certainly something that does come up. These relocations happen. Your employer may tell you, you used to work over here, now we're going to move you somewhere else, and what do you do? So the question ultimately is, how does this affect you? So you may not like the move, but if it doesn't really affect you in a huge way or a significant way, you may not be able to do anything about it. On the other hand, if it's a big move in the sense that now you're going to take an extra hour each way to get to work, kind of like that hour threshold, or it's going to cost you much more. Maybe now you have to get a car. Before you used to be able to take a bus. There's just no bus that goes there. You have to get a car. That is a significant move, meaning your employer cannot just impose a change like that. Ultimately, if you say no to that, and as a result you lose your job, that will be a without cause termination, and you'll have to get severance. Remember, you can't physically stop your employer from changing work location, but you may be able to treat that as a termination. Some of this also depends on how much advance notice you've received from your employer. It's one thing if they give you a year's notice, another thing if they said it's next month, so the devil's in the details. But those are some of the rules that apply with a change, with a relocation. Again, as I say always, especially when it comes to something like this, before you say yes or no, before you go buy that car, before you quit your job, call me so we can talk about the details.
So with this particular issue, Lior, it's come down to relocation. It's not a matter of kilometers, it's a matter of time, right?
Absolutely. It does not matter really how many kilometers away they're relocating. It matters the effect on you. If they moved many kilometers, but it actually ends up being closer for you, that's a good thing. The number of kilometers may be small, but based on traffic or your car situation, it may have a massive effect on you. So the question is, how does this affect you? And kind of a threshold that I use is that hour. If this move means an extra hour for me, more than I used to with the regular location, that is a significant change. That can absolutely be a constructive dismissal. If it's 20 minutes, 30 minutes, it's probably not enough. So again, that's some general guidelines, but as always, the devil's in the details.
And I've asked you before, is this something you can go to the employer, say in writing, can I try this to see how it affects me? Because I love working here, all my colleagues are here, I've been here for many years, I don't really want to go, right?
And that actually would be a very reasonable thing to do. Yeah, I don't like this, but maybe I can manage it. Maybe, you know, my significant other and I can figure out how to share the car, or you know, maybe it's not going to take as long as I thought to get there. So it's okay to tell your employer, hey, employer, I don't know that I can do this, but as John said, I want to continue working here, so I'm going to try for a little while and then tell you where I'm at. You can absolutely do that, and if it turns out it's not so bad, you're still happy, no problem. If you're still feeling, no, this is not good, this is going to take a long time to get to work, I'm not okay with that, you would still then be able to say constructive dismissal.
All right, good stuff. Let's move on to our weekly topic for this week's Fast Facts about employment contracts. Number one, employment contracts typically are there to protect the best interests of the employer by limiting things like severance pay.
So written contracts almost always benefit the employer. And the reason for that is you have rights that are there, whether you realize it or not. They're just there, they're imposed by law, and they're there. But what our laws have also said is, well, if you don't really want these rights, you can give them up. We're not going to force you to have them. And that's what an employment agreement, a written contract of employment, often does. It takes away the rights that you would normally and automatically have and gets rid of them. So that is a huge problem. So when you're seeing a 10-page employment agreement that your new employer wants you to sign, I can almost guarantee you that in that 10 pages, there's going to be at least half a dozen things that are not favorable to you, that take away rights that you have. An example that John just mentioned, severance. An employment agreement can try to limit your future severance. That could cost you tens of thousands of dollars. Another example may be a situation where that employment agreement gives the company the right to change your pay, to change your job responsibilities, to change your hours. Your employer doesn't have the right to make those changes unless you agree in an employment agreement to give them that right. So you've negotiated a salary of $75,000, but you also agreed that they can change it at any time. Well, what's the point of even negotiating that? An employment agreement can also give the company the right to put you on a temporary layoff. They don't have a right to do that unless you gave them that right. And I can keep going. So generally speaking, you are not, don't ignore those things. Don't just look at what your salary is. Don't just look at how many weeks vacation. There's other important terms, and that employment agreement, if you can avoid it, you're better off.
Send it to Lior, by the way, if you want to. Help at employmentlawyer.ca. Have a look at it first before you sign anything. Number two, you do not need to have a written formal contract at the start of a new job. This is going to send people for a loop because we love paper. We love security of a mortgage contract, a car lease, all these things. You like to have pounds of paper. But here, not so much.
Not so much. And someone that just watched me or heard me may say, well, okay, you told me that employment agreement is not good for me, but I need to have one, so what do I do?
Right.
Well, no, you don't need to have one. There is no legal reason why you need to have a signed employment agreement or job offer letter or contract of employment, whatever you call it. It's not needed. By not having one, by having a handshake deal, by writing something on the back of a napkin, I don't think anyone actually does that, but by doing that, that means you have the full protection of the law. I would much rather have an email from my new employer saying, hi, Lior, you're starting Monday, your job is this, your salary is that, we'll see you then. I would much, much rather have that than a 10-page document, because I can guarantee that in that 10-page document, there's going to be plenty of things that are not favorable to me, the employee. So if you're given the opportunity not to have an employment agreement, don't ask for one. And certainly, if you are offered an employment agreement to sign, before you do that, let me see it. Let me tell you what it means, what it does, so that you're not taken by surprise.
Well, for the third fact, we'll take it one step further, right? Your employer can't force you to accept a new employment contract. In fact, to take it a step further and say that's bad news if you get one of those, right?
So you're working, it's not a new job, you've been there for a little while, and your employer now walks up to you and says, hey, employee, I want you to sign a new employment agreement. No, not so fast. Remember, as I said, that employment agreement is not favorable to you. It's favorable to the employer. So if your employer all of a sudden wants you to sign a new employment agreement, is because there's going to be things in that agreement that are more favorable to the employer at the employee's expense. So those bad terms that I've talked about are likely going to be included there. Now, from the employer's perspective, sure, I understand why they would want that. And if I was talking to an employer, I would encourage them to do that. But from the employee's standpoint, terrible idea. You cannot be let go, by the way, for refusing to sign that agreement. Certainly, you cannot be let go for cause. If they want to pay you severance, they can. You cannot be punished. But certainly, at a bare minimum, if you're an existing employee, your employer wants you to sign a new employment agreement, don't do that without having me see it first, reading it, and tell you what you're potentially agreeing to.
Do you have any bargaining power with that new employment agreement? After you've read it, of course, right?
Absolutely. Usually, if you do this correctly, you approach the employer the right way and express concerns, you can negotiate terms. So just because your employer has offered you something to sign and it says certain things does not mean you're stuck with them. You can negotiate them. And oftentimes what I do is advise individuals how to do that, how to approach the employer, what to suggest, what offers to make. And most of the time, more often than not, we're able to make those changes.
Okay, one more fast fact about employment contracts here, Lior. Before signing a new employment contract, it is in your best interest to speak to an employment lawyer, of course.
So you got a new job offer, you're excited, you can't wait to start. Man, I was hoping that they'll hire me as the assistant manager and pay me this salary. They did. I'm very happy. My gosh, I was hoping for 3 weeks vacation. They've offered me 4. I am over the moon. That's fantastic. Well, there are other things, as I've said, that are potentially even more important, which is why we need to look at it. Give you an example. What if your employment agreement says that they can let you go, pay you almost nothing, and by the way, if that happens, you can't work in the industry for 2 years? Are you still happy about that 4 weeks vacation? Well, I think you get the idea. So yes, we need to speak about it. We need to make sure that you know what you're signing and potentially negotiate proper terms. Again, if you're not asked to sign a new employment agreement, consider yourself fortunate, but if you are, we should always talk about it.
And again, always reach out to Lior with that new employment agreement if it happens to you. Phone him 1-855-821-5900. Email help@employmentlawyer.ca. We'll get to a live stream question after a short break, which we'll take now, and we'll come right back. So stick around and join us then. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Welcome back, Employment Law Show. Always reach out to Lior and his team. Phone calls, your number one avenue? Sure, 1-855-821-5900, or email your concerns, help@employmentlawyer.ca. And the website that tells all, and also has the severance calculator, which has been around for not decades, been around for years, but it has helped millions across the country. That is not hyperbole, literally millions. So check that out at pocketemploymentlawyer.ca. And you can reach Lior in the live stream and his other colleagues at the firm. You can do that on Facebook, YouTube, LinkedIn as well. The address is @stlawyers.ca, @stlawyers.ca. Okay, question for this week, Lior, is this. I was recently fired after a disagreement with my manager. My employer told me I'm only entitled to 4 weeks' pay due to performance issues, but I'd never received any negative criticism before my termination. After 8 years in this sales role, I thought I'd be given much more. I'm nearly 50 years old.
So we have to remember that there's really only two ways to have your employment terminated. There's a termination for cause and without cause. There's really nothing in between. Now, a termination for cause means you've done something so bad that the company can just let you go and pay you nothing. That is extremely difficult to do. The company has to prove that what you did is just bad enough that this relationship cannot be rehabilitated. It's over. We have to let you go. We don't have to pay you any severance. Now, the other end of it is anything that's not a termination for cause. Anything that doesn't meet that very strict test is a without cause termination, meaning you're owed your full severance. The employer doesn't get to say, well, this is kind of cause, not really, but kind of, so we're going to pay you less. It sounds like this is exactly what this employer has tried to do. Clearly, whatever this employee did is not bad enough to be cause. So the employer doesn't get a discount. They have to pay the full amount of severance. Even if you've done something wrong and you lose your job, you're still owed your full severance in most cases. So the next and last question is, okay, not 4 weeks, we know that. They don't get a discount. How much severance is this person actually owed? We're going to go back to pocketemploymentlawyer.ca, use the severance calculator, and let's see what that gives us. So we know that this person has been there for 8 years in a sales role, 49 years of age. The employer says 4 weeks for some reason. I don't know why. Well, it doesn't really matter. You see at the bottom there that this person is owed anywhere from 9 to 12 months of severance. Their full severance. That's why you go to pocketemploymentlawyer.ca. That's why you check it out for yourself, because chances are whatever the company says you're owed is not the real amount.
Okay, moving on to yet another website where you can reach Lior and his team, terminationquestions.com. Free and anonymous, ask your questions there. And here it is for this week, Lior. I've been with the company for 15 years in maintenance. For the first 8 years, I was an independent contractor, and then I became an employee. If I'm let go, will those first years count towards my severance entitlements? Silly wabbit, you're not a contractor.
You're not a contractor. No. You don't magically turn from being a contractor to an employee or from an employee to a contractor. You're likely an employee the whole time. Likely this person was misclassified, and for the full 15 years working in maintenance, he was an employee. That's important to remember. I get this question asked often. I worked for this many years, but for the first few years, I really wasn't an employee. Of course you were. The fact that the company didn't say that you were or called you something else, that doesn't mean that you were something else. Remember, the company doesn't decide what you are. You don't decide what you are. I don't decide what you are. The law makes that determination. And as I always like to say, if you look like an employee and act like an employee, yeah, you are an employee. Nothing else matters. So yes, he was a 15-year employee. If he loses his job, he's going to get severance as a 15-year employee. Same with you at home. By the way, if you want to know if you've been misclassified, if you truly are an employee or a contractor, we have a tool for that as well. You can also go to pocketemploymentlawyer.ca, click on our independent contractor tool, answer a few questions, and find out if you're an employee or a contractor.
Okay, it's time to crank up the speed on Lior for a bit here as we get into our employment rights rapid fire. Let's get this done. Question number one, Lior, here we go. Are salaried employees exempt from overtime pay?
No. You get overtime even if you're on salary. For in Ontario, for example, anything over 44 hours a week, you get time and a half, even if you are on a salary.
Rapid fire number two. Can an employer confiscate an employee's personal device during work hours?
So an employer can certainly have a policy that says you cannot use your personal device during work hours. It would be inappropriate for the employer to take away someone's personal property.
Number three, rapid fire for this week. Is an employee owed severance pay if the company is sold?
So if you lose your job as a result of a sale, yes, you are owed severance and your full severance. If you continue working with the buyer, then no severance is paid at that time, but the buyer likely inherits your service. So be careful with what you sign. You don't want to give up that service in case down the road you're let go.
Number four, can an employee be forced to return to work if their disability benefits are cut off?
No. So ultimately, the question is not, are your benefits cut off? The question is, what is your doctor saying? If your doctor says you still need to be off work, you can be off work regardless of what happens with the benefits. So that's what matters.
Finally, can an employee be demoted as a form of discipline?
So In rare situations, yes. If what you did is bad enough that it's pretty much almost cause, the employer can say, we're not going to let you go. We're going to do something a bit less than that, a disciplinary demotion, but that's rare.
And we just got it in time. We're out of here. We're out of time. So the phone number one more time, 1-855-821-5900, help@employmentlawyer.ca and pocketemploymentlawyer.ca. We'll see you again next week.